Imagine an immigrant applying for a U.S. visa. They have a spotless criminal record and a lucrative job offer waiting for them. But at the final step, their application is abruptly denied. The United States border operates as an active epidemiological shield, filtering out threats before they ever reach domestic soil. The legal mechanism powering this shield is Section 212A1 of the Immigration and Nationality Act, which enforces a strict medical background check. This specific statute outlines 4 distinct health-related roadblocks. These criteria blend biology and behavior, and triggering any one of them will halt a visa application in its tracks. Achieving the American dream requires proving you do not pose a biological or psychological threat to the general public. The first pillar focuses on biology, specifically Clause I, communicable diseases. The law targets diseases of public health significance, meaning a standard cold won't trigger this, but highly contagious and severe illnesses will. The second pillar, Clause II, shifts to preventative medicine. It targets applicants who are missing required vaccinations, a rule that applies specifically to those seeking permanent residency. As these medical vials suggest, the government enforces a high clinical standard. The law requires applicants to present documentation proving they are immunized against specific preventable diseases like mumps, measles, polio, and hepatitis B. However, there is a crucial legal nuance written into Clause C, a special immunization exception carved out for internationally adopted children. Looking at this young girl receiving a shot, we can see the historical focus on pediatric health standards. This pediatric exception applies only if the child is 10 years of age or younger, requiring prospective adoptive parents to execute a formal affidavit. The affidavit is a legally binding promise that parents will ensure the child receives the missing vaccinations within 30 days of entering the United States. Together, these first 2 pillars create a strict screening system, policing the physical transmission of biological threats long before they can take root inside the country. The second half of the statute pivots away from infectious diseases and toward behavioral dangers. This brings us to Pillar 3, physical and mental disorders. A critical legal distinction must be made here. Simply possessing a physical or mental diagnosis does not automatically disqualify an applicant from receiving a visa. The actual legal trigger requires 2 elements. A diagnosis must be directly coupled with behavior posing a tangible threat to property, safety, or the welfare of others. A history of such behavior also triggers inadmissibility if the harmful conduct is likely to recur. This behavioral logic carries directly into the 4th and final pillar, drug abuse or addiction, found in Clause 4. Determining who qualifies as a drug abuser or addict isn't left to the subjective opinion of a border agent. It relies strictly on medical regulations prescribed by the Secretary of Health and Human Services. When you read the statute as a whole, it becomes clear that U.S. immigration law treats unmanaged psychological volatility and severe addiction with the exact same severity as a highly contagious virus. So what happens if an applicant violates one of these 4 pillars? Is their visa application permanently dead? Not necessarily. The Department of State holds the authority to grant specific legal remedies under INA Section 212G, known as the waivers of ineligibility. For instance, a communicable disease waiver is available, but it is heavily reliant on family ties. An applicant typically needs a qualifying family member, like a spouse, parent, or child, who is already a U.S. citizen or lawful permanent resident. There is also a medical bypass for the strict vaccination requirement. If a certified civil surgeon officially determines that a specific vaccine would not be medically appropriate for the applicant's body, the requirement is waived. The law even provides an ideological bypass. The vaccination mandate can be waived if receiving the shot directly contradicts the applicant's sincerely held religious beliefs or moral convictions. These waivers exist for a precise reason. The law recognizes that absolute health security cannot completely override complex medical realities and fundamental human rights. We are left with a medical border that operates on a dual, seemingly contradictory nature. On one hand, Section 212A1 provides an uncompromising shield against legitimate biological and behavioral threats to the public. But zooming out, the U.S. immigration system operates as a highly calibrated filter. It relentlessly protects public safety while offering precise humanitarian pressure valves to keep families together.